Okay, now we have everyone. All right, counsel, when you're ready to start.
May it please the court, my name is Louis Figueroa and I represent the plaintiff appellant in this case. I think that this case is pretty straightforward. The problem is with the results that were given. So if I can, I just want to reiterate just a couple of things. The facts are simple. The defendant, Abraham, was a Virginia resident traveling on a business employee, traveling on business to Florida. He worked for defendant Cisco as a professional engineer. He was sent to Tampa, Florida to provide on-site support for a
Mr.
Cisco.
Figueroa, I think we're aware of the facts. Let me ask you this. I want to see how far your position goes. Any time that an employee works off-site at a customer's location with his employer paying some or all of the expenses of the trip, the employer is responsible for any harm that employee causes 24/7. Is that as far as you go?
I'll answer that if I can. If he's an out-of-state employee being sent on a specific mission and he's staying in a hotel, and the only reason he's in Tampa at all is because of his employment, then yes, I say his going to a work site, there's no break in chain, my argument, there's no break in the chain of his employment, so he's under the auspices of that. If he takes
so let me give you an example. I mean, I was in private practice, you're in private practice. So you go out of town to handle some depositions. And of course, you're going to get reimbursed by the firm for the hotel and for the rental car. So the depositions are over for the day, and you drive to a restaurant to have dinner with the lawyers involved, and unfortunately you get into an accident. The law firm is responsible for your conduct?
And Your Honor, on that question, I would say yes, because again, you're going from point A to point B, still in the process of that employment to meet with the lawyers on the case.
Why is that not a long stretch to make Fiero apply to that situation, don't you think?
No, not as long as there's a continuity of the employment practice. If you're
the guy's at his hotel sleeping, and then he gets up in the next morning, he drives to the client's customer.
Right, but the reason he's in the hotel and the reason he's in Tampa, respectfully, is for that employment. If instead of that, he drives to Disney World or to Tampa Stadium to catch a game, that breaks that employment purpose, okay? But in this case, my argument is the employment purpose is getting up from the hotel and showing up at that work site. The reason he's going on that route, the reason he's going to that particular work site is business related.
And how is this different than all the other cases that say when you're going to and from the work site there's no respondeat superior?
I believe that the other cases can be distinguished on the basis of the person's leaving from his home, or he's leaving from a place that's not connected.
I think I at least read in dicta, or cited by parties in their briefs, that there were, at least in dicta, maybe more, I'm sure opposing counsel will correct me if I'm wrong, that it was more than dicta, that even if it's the individual's not embarking from his or her home, but rather from a hotel, the rule still applies.
Okay, and our position is, again, that the only reason he's in this work site or this hotel, the only reason he's in town, the only reason he takes the route that he took was because of his employer. And in this case, there's another portion, and I don't want to recite the facts. They have a contractual relationship with that car, and they say, hey, we're responsible for anything that happens to the car while it's under our auspices. We pick the insurance. We do everything to handle his use of that car while he's in Tampa or any other location for business.
Suppose the fellow is working in Virginia, and the company decides that he needs to, let's say he lives in Falls Church, Virginia, and the company says, you have to go on site to work at a company in Richmond, and you're going to be there for 3-4 days. We're going to pay for your car. We're going to pay for your hotel room. Same result under your theory?
A little different. And again, to me, it's fact specific. It all depends on what the purpose is that he undertakes that day. If he's in a different city, he's sent there, or in your deposition question, if I'm in Richmond, taking depots, and then I'm going to a depot site again in the morning, so that the purpose of the trip is work related, then it's my argument that yes, the employer should be responsible. And I know that it's of no precedential value, but we argued the Middle District Court where a similar outcome happened. And the similar argument that I'm making is in that particular position.
But in that case, there seemed to be no question. The parties seemed to concede that the employee was within the scope of her employment. Correct?
That's correct. That's the factual issue in this particular case that we argue precludes summary judgment.
Okay.
Anything? Any other questions? Again, our position is predicated on the fact that everything that happens, the accident happens between the position he's at, the hotel that occurred, and the specific work site. So there's no break in the work continuity. And I'll reserve.
Thank you.
Okay, I'll reserve the rest of my time if I can for.
All right, thank you.
Thank you.
May it please the
Mr.
court.
Reed?
My name, excuse me. I woke up with a frog this morning. My name is Ben
Just
Reed.
this morning.
Yeah. Ben Reed with Carlton Fields, and I represent the appellee in this case. I think I can very quickly move to the case law that we're talking about. The plaintiff basically tries to make three, what I'll call quasi-legal arguments. One is he distinguishes every single case that we cite that's been decided over the past 70 years, which provide that the going and coming rule would apply to this case and that it would preclude liability. Secondly, he conflates workers' compensation cases with negligence cases and cites. He'll give a cite, he'll make a statement, and then he'll cite the opposite case. And then finally, he raised, for the first time on appeal, that somehow we, quote, own the vehicle, which would cause the dangerous instrumentality principle to apply. But that was raised for the first time on appeal. And plaintiff concedes in his brief and in his papers that Hertz owned the vehicle. But I'd like to talk about the controlling authority. If you review the cases that started in 1946 up through 2019, they reveal that the coming and going rule has been universally applied in negligence cases such as ours. Now, the most pertinent case Judge Rose mentioned already is Fierro, and that's the only case in the second district that deals with the issue. There, the employee was driving a privately owned vehicle between a temporary resident, presumably away from home, and work. And the court found that the court was asked to adopt the traveling employee rule of workers' comp, and the court declined to do that.
Mr. Reed, why should it make a difference on the business trip scenario that Mr. Figueroa has laid out? The employee is out of town for the client, and every nickel that the employer pays is for the purpose of advancing its employee to be close to the client. Does that make a difference at all in your analysis?
It doesn't make a difference when you consider to any of the courts that have decided these cases since 1946. I think there's a difference between workers' comp and negligence cases. workers' comp, the plaintiff in the workers' comp cases they cite are all the employee who's been injured. There's a policy which the courts talk about, that workers' comp is different from negligence cases. The whole trade-off between getting swifter justice, perhaps you don't get the same recovery, but you get swifter justice and so forth. And then the employer gets the benefit of no litigation. So they're two separate things, and this court in Fierro, and as well as the other cases that I'll talk about, have all adopted this. Now, once you leave Fierro, if you go through plaintiff's various attempts to distinguish the cases, I've tried to group them because he makes several different factual arguments, and he says this case doesn't apply for this particular reason. Well, if you group the cases, I'm going to go through about 3 or 4 groupings. Number one is the situation where the employer leased or owned the vehicle. And that's the Jones case, where the employee was traveling through multiple states and the accident occurred away from the state of the residence. There's the Robello case, where the wife of the employee was driving a company-provided vehicle when the accident happened. And perhaps the most significant case is the Garcia case out of the 4th District, and that was a police officer driving his police cruiser, which obviously he was being paid for his work. He was driving a company-owned police cruiser to work, and the court found that there was no liability under the going and coming. That'd be the 11th Circuit, the 3rd, and the 4th. Now, if you move to the next group of cases where the employer paid.
Mr. Reed, that last case you referred to, though, we're just talking about a regular commute, are we not? Albeit in the cruiser.
That's one of the situations, yes, sir.
Okay.
Yes, sir. Now there's a situation where the employer pays all the expenses, and this really follows with the question that you just asked. The Holloway case was an Army officer in reserve who was out of state, traveled away, was paid a per diem, all his expenses and so forth were paid, and the accident happened out of state before he got back, and the court in the Middle District, applying the same principles of Florida law, found no liability there. The third category would be where the employer provides some of the expenses. And the Foremost Dairies, which is a seminal case, 1946, where the employer only paid for gas, tires, upkeep, mechanical. And the court found that the rule applied there. And that's the case that continues to be cited. And in the Freeman case, in the 1st District, the court found that even if the it was not directly on the point, but it said even if the employer paid some of the portion of the upkeep, the rule would still apply. Then the other permutation that the plaintiff attempts to rely on is that you're away from home or away from the work, away from your site of your work. And the first case there is Fierro, where they were at a temporary residence, and which I've mentioned previously. The King case in the Northern District was a salesman who worked in another state. The accident happened in another state. He was paid to go to that other state for sure. And the result there was that the principle that we advocate was applied. I mentioned the Jones case already, where the Army Reserve officer the Jones case where the worker was traveling from job to job to job in a leased vehicle, by the way, and the accident happened in one of those jobs. The court found the rule applied to that factual situation. And then the Holloway case was the reserve officer that I mentioned previously, and it falls into this category. Now, in addition to the cases which have basically gone through the various factual arguments the plaintiff has attempted to use to distinguish this authority, you've got the Hernandez case in the 1st District, and where an employee was just simply going to work, had a seizure, and the court found, relying on Foremost Dairies again, and Freeman, and that was a 2005 case. And then 2 years ago, in 2019, in the 5th District, the Dupree case relied expressly for the same principle on the Foremost Dairies, on the Freeman case, and on the Hernandez case. So when you look at this whole 70 years of authority, you see virtually every permutation, and certainly every one the plaintiff has raised in this case, has been considered and rejected as a means of avoiding the coming and going rule. I mentioned that the plaintiff attempts to conflate workers' comp with negligence cases. But on page 26 of the brief, the plaintiff concedes, as Fierro says, that the traveling employee exception does not apply to workers' compensation cases. And then he cites 3 workers' compensation cases, presumably as authority for his position in this case, which of course is not. That'd be the Edie, the Grillo, and the Hudak. Those are all Supreme Court cases, appeals from the Workers' Compensation Administrative. There were 2 cases where the employee didn't have a job, didn't have an office. And those were accepted, the plaintiff relies on. And the court said in those cases, since the employee is working from the day leaving the office on, you have a different result. And then finally, the case that counsel cited, it's the Benway or the Williams case. The court excluded routine commutes in that case. So our position very simply is, Your Honor, is that based on 70 years of uninterrupted authority, we would request that this court join your brothers and sisters over the 70-year period and affirm the summary judgment which the court granted. That's all I would say unless the court has any specific questions.
No, thank you, sir.
Thank you.
Okay,
Thank you. May I proceed, Your Honor?
yes, you may.
And again, I'm a lover for being succinct, my style. He mentions Fierro, and Fierro, if you read Fierro, it adopts a suspect, which states that the employee is in the course and scope of its employment under 3 points. 1, the conduct or type of employee, the type of employment the employee is hired to perform. And in this particular case, the employee was required to work out of state and is required to drive a vehicle provided and paid for by the employer. And the accident occurred while he was doing that. The conduct also, number 2, occurs within the time and space authorized for work. And that element is satisfied because he's out of work and requires travel to the work site from his hotel. And that's the purpose where he was going when this accident occurred. Lastly, whether or not the conduct that he's engaging in at the time benefits the employer. And again, he's in Florida, he's at that hotel solely to work and go to the first meeting that he had that day, and he's provided that vehicle. There were some cases that were cited at the very end that my opposing counsel says are years in the making. However, all those can be distinguished because they hold the employer liable if the accident happens in transit to the workplace, if the employer provides transportation to and from work and provides, and that's a Haddard case, provides compensation for that. The whole premise of my argument, okay, is that at the time he was engaged in a work activity, which is going from one place where that was provided to him to that first place of work. In any event, if the court needs more clarification, then I think that states that this is not a summary judgment issue, but rather one that can be presented and establish exactly what his parameters were to go back and forth to that work site at the beginning of the day. So summary judgment would be precluded under that situation as well. Those are my arguments, Your Honors. Any questions?
Okay. No, I don't think so. Thank you both for
Thank
your
you.
arguments. We're going to take a 10-minute break before we reach our last case today. So